Welcome back, everybody, to the Law of Tort. We're moving on to the fourth major topic in this series of lessons today, talking about the talking about the concept, shall I say, of causation. This is going to be the next of our lessons in a series of lessons on the Law of Tort, talking about the concept of causation in this chapter. We're going to examine all the elements of causation, all the considerations that may be required to understand causation, before we then start looking at other torts that are not negligence. So we'll talk about employer and vicarious liability, for example, occupier's liability, intentional torts, nuisance, defamation, etc., etc., etc. Let's just refamiliarize ourselves one more time with the negligence equation. So when we think about negligence, when we think about what we need to do to show somebody has been negligent in the performance of a specific action, we have to think about these three considerations. We have to think firstly about the duty of care. We then have to think about whether or not that duty was breached, and in doing so consider things like the reasonable person test and the standard of care and all these different things. And then once that has been established, it must be shown that that breach had caused the damage that was incurred onto the claimant. Only when this can be shown will we find that there is liability in the case of negligence. So this series of lessons is going to focus on this third and final element of the concept of negligence. Now, theoretically, causation could be divided into two. We can talk about causation in fact as well as causation in law and remoteness, which we are going to do. Essentially, we're going to cover both of these things, but I've just sort of grouped them together under one umbrella, the umbrella of causation. So, unlike some of the other elements of tort we've been exploring, the concept of causation is not just related to the tort of negligence. It is in fact something that is important to consider for pretty much every other tort that we are examining. In fact, it is important to consider in a lot of other areas of the law as well. You will find causation in the criminal law. We've actually spoken about causation in the criminal law already on this channel. You'll also find causation and issues related to causation in the law of contracts. We will get to that in future lessons' time when we cover more lessons on contracts. So causation, essentially, is a concept that you will understand and would be very easy for you to understand given the expectation of the ordinary meaning of the word. In the context of negligence, causation essentially asks us to think about whether or not the breach of the duty of care, that failure to meet the standard of care that we've explored already, whether or not that was the cause of the damage done to the claimant. Essentially, so far, all that we have established is that there was a duty of care, that duty of care had been breached, and that there was some damage that was that had happened to a claimant, okay? But we haven't yet considered how the breach of duty causes that damage, because that is what's required, okay? You can have circumstances where there is an individual who has a duty of care, and then that individual fails to meet that duty of care, and then there is a breach of duty of care, and that a claimant has damage incurred onto them, but there wasn't a causation, that the breach and the damage were not causally linked, and as a result of which there is no claim. The person whose breach of duty was not liable for the damage to the claimant. Because why would that be fair, just, and reasonable to expect a defendant, just because they have breached the duty of care, to have to pay compensation for the damage done to a claimant if they were not the cause of said damage? There are multiple ways in which this is examined, the concept of causation, okay? And we will get to the ways in which this is examined in future lessons' time. Ultimately, causation is referring to this idea of the actions of one party being the cause of another. And there are multiple different considerations. There's things like material contribution to a particular illness or a particular damage that is caused. We'll consider something known as the Fairchild Rule for specific cases of a specific kind of cancer, a specific kind of lung cancer as a result of asbestos, which sort of breaks the ordinary rationale of basic causation cases. And we will also talk about the idea of there being new intervening causes. So the idea of new things contributing to the damage that represents what are known as novus actus interveniens and may potentially absolve an individual from liability.